and in the next fiscal year with respect to promoting safety and health for workers, but more so to thank you for the opportunity to discuss what we are doing together. I have to tell you that OSHA and NGFA have been working together for quite some time in a hopes of preventing, reducing, I'm sorry, can you all hear me? All right. Reducing injury, illnesses, and fatalities in the grain handling industry. But we've been doing that more on an informal basis until September 13th, 2017, which I'm sure you've heard of or you will hear more about, when OSHA and NGFA entered into an alliance where we formalized our collaboration. It was a wonderful opportunity. We were very eager to do it. Some of the products, though we've only been in it not quite a year, we've had some phenomenal successes and some products as part of that alliance. Our first ever, the first ever nationwide stand-up to prevent grain engulfment took place this past April 9th through the 13th was the week that we focused on it. Leading to the actual stand-up event, there were several educational webinars that took place to introduce and to discuss hazards in the grain hazard industry. In addition to all of that, a plethora of safety and health training and educational materials were posted on the stand-up website, which was sponsored by the University of Texas in Arlington. And I want to thank all of you, all of the individuals who participated in the stand-up or viewed any of the educational materials or sat in on any of the webinars. Thank you for making it such a huge success. And I hope to continue the process. It's a 3-year alliance, so I hope to continue the stand-up in the process and further advance safety and health in the industry, in the grain handling industry. I will tell you what is the state of safety and health, worker safety and health in nationwide. What is it right now? And I'm sure all of you have heard, have read, or participated in some of these headlines. And it's shocking to me, right? These are just a few, and you can open a newspaper, you can read a professional journal, and you'll see data reflecting about an increase in injury illnesses and an increase in fatalities. These are just a few. Workplace injuries on the rise was recently published, June 2018, in a New York workers' compensation article. Death in construction on the rise, 27% year on year, was just published in Construction News. Worker deaths continue to rise in Massachusetts, the Boston Globe. Region 7, which I think Jess talked about, Kansas, Missouri, Nebraska, and Iowa comprise Region 7. We are not an isolated instance, nor are we immune from a rise in injury, illnesses, and fatalities. We published an article, a press release was issued July 9th, reflecting the fact that Region 7 alone, as of that date, July 9th, had experienced 39 fatal incidents. We'd investigated 39 fatal incidents, which resulted in the death of 42 workers. That's one worker every week, right? Now, granted, they're not all in grain handling, but it's a startling increase over what we experienced last year. Last fiscal year, at the same time, we inspected 25 fatal incidents. This year, we're up to 39 already, and we've had more reported this week, I am sad to say. So what are we doing about it? Every time I do a presentation, every time I go out in public, whether I'm in Washington or in Missouri or wherever I might be, I'm asked by people, what are you doing about it? What is OSHA doing about it? That's your job, to prevent injury, illnesses, and fatalities. Is it my job? Is it exclusively my job? No, it's not. It's a shared responsibility. We all play a role, a responsibility in reducing injuries and illnesses. We all play a role, from the agency to employers to employees to unions. We all play a role and have a responsibility, right, to reduce injuries and illnesses. Well, the agency is tackling, well, how do we do that? What's going on out there? And then we understand there is a multitude of factors contributing to the rise of injuries and illnesses and fatalities across the nation. There is a multitude of different employer attitudes out there. So by the agency's perspective, it's a balancing act to try and get a handle on what's going on out there and what are we going to do to turn it around, right? It's a balancing act between the two major categories, or the two major tools OSHA has in its toolbox, are compliance assistance, which is what we're doing right here, right? And which is what you're involved in, a national alliance, right? We have high hopes that compliance assistance will really have a strong positive impact on turning around those injury illness rates. But again, it's a shared responsibility. And of course, what the bane of most employers is enforcement. OSHA always has at its disposal enforcement capability. But the two are not mutually exclusive. They rely on one another. They work with one another. They're complementary to one another, right? Everybody's seen the curve, whether you're in elementary school or grade school, but OSHA is tapping into this curve, this safety performance curve, to really make a point. We understand that the bulk of employers are in the center, in the bell of that curve. They really, really want to do the right thing. They really want to protect their employees, worker safety and health, but they may not have the tools, whether it's educational materials. They may not know what the right thing is or how to go about doing the right thing, but they want to do the right thing, right? Unfortunately, there is and there always will be employers that are on the far left side of the curve, right, who really don't have the right attitude the agency is looking for to really protect worker safety and health. They either condone or oftentimes encourage unsafe practices, right? But very fortunate for all of us, the agency, employers, employees, and unions, we have that cadre of employers that are on the far right side of that curve who really get it, who have exemplary safety and health programs, as I'm sure all of you do. Right? It's those employers we want to rely on, we want to leverage, we want to reward and acknowledge and reinforce the practices that they have in place. And we want to eventually move all of those employers from the far left side and the bell to that far right side. And collectively, collaboratively, we can do that. We can do that. So how are we going to do that? To go back to our tools. And I know most people don't like hearing about the enforcement end of it, enforcement activity, but it's a reality, at least at this point in time. So what do I mean by enforcement activity? And I make a point of listing all three of these because they all play a key role in enforcement activity. There's the inspections, where you're greeted by a door-to-door safety and health compliance officer who's more than willing, more than happy to impart their wisdom in terms of the safety and health regulations and how it applies to you, what the hazards are. So you receive an actual inspection. We also have investigations where you don't receive an inspection, but rather you get a call or you receive a letter from a compliance officer or an OSHA representative telling you that a hazard has been alleged. We need you to investigate it. And then if it is true, if you do have the hazard, what are you going to do about it? What are you going to do to fix it? Okay? So those are the investigations, and I'll get back to those in just a few minutes. But I also want to make special note of special emphasis programs. The agency uses special emphasis programs to really get a handle on what's going on out there, what's going on in industries out there, what's causing them to be a high hazard industry, or if we're targeting a specific hazard, say lead or grain handling, what are the hazards associated? How can we hone in on what those issues are, educate, train, and reinforce to employers what the hazards are and the steps that they need to take to really remove or mitigate those risks? And there's three types of special emphasis programs. That may not mean a whole lot to you, but there are three different types. There's national, the whole OSHA realm adheres to it. There's regional, where it's specific to a region or maybe multiple regions, or local emphasis programs. And Region 7 has some of both, and I'll talk about a few of them. I thought this was an important slide for you to really look at. Everybody's always concerned about inspection numbers. But now the slide, the bar graph, talks exclusively about the grain handling industry. You'll see on the bottom it's the 5 NAICS codes that we're addressing under our grain handling LAP. To date, but to give you some background, to date, the agency as a whole has conducted slightly over 30,000 enforcement inspections, the whole nation. Region 7 has conducted about 1,900 inspections. In the grain handling industry, we've conducted 136 inspections. 7% of the inspections that we have done to date, well, as of last Friday, were in the grain handling industry. And you will see, if I can work this little slide, this little pointer, can you see this? The bulk of the inspections have occurred in this NAICS code, which is the grain and feed, the wholesalers, merchant wholesalers, right? And you will see, what's most important is you will see the disparity between FY17, which is in blue, and FY18 to date in orange. Now, they're both to date. I stopped them both, so they go from October 1st to July 20th. I ended on July 20th. So you see a slight increase in the wholesalers, right? Inspections in wholesalers. And I will talk about that in just a moment, why that's happening. More importantly than the sheer number of inspections, I think, is how we got there. And there's multiple reasons why OSHA can pay you a visit, right? We have complaints, we have referrals, God forbid, fatalities, or we can target you for an inspection. You will see, and why I put this up here is the importance of looking at it. Don't let me walk off the stage here when I'm backing up. The difference between FY17 and FY18. This is 17, this is 18. You will see in FY17 there's a higher number of inspections that were conducted as a result of complaints, right? You will see a higher number, in red, you will see a higher number of inspections that were conducted as a result of employer-reported referrals. Now remember, the record-keeping guidelines or record-keeping requirement changed in January 2015, where employers were required to report all amputations and hospitalizations to the OSHA office, right? As well as loss of an eye. But I have yet to observe a loss of an eye reporting, right? So there were a higher number of complaints than employer-reported referrals. But look to this year, FY18. What do you see? You see an increase in the number of fatalities. That's the dark, that's the dark blue. You see an increase in the number of follow-up inspections, right? And you see an increase in the number of planned inspections. Those all interplay with one another, right? When would OSHA do a follow-up inspection? When do we do follow-up inspections? Oh, you don't have to answer that, right? We do follow-up inspections when we identify a fatality, following a fatality. We do follow-up inspections when we issue a high number of high-gravity serious citations, willful or repeat. But the value of a follow-up inspection is to ensure that the employer did what they said they were going to do. You abated the hazards, right? That's an easy task, right? That comes into play in the next slide. Citations issued. OSHA, you will see the difference between FY17 and FY18. A larger number, there's always a large number of serious violations, and if you've read the definition of what a serious violation is, the preponderance of the violations that OSHA issues are always serious. They have different gravities, different probabilities, different penalty calculations, but primarily serious. Shoot. Okay, look at the difference, wrong button. Look at the difference in the dark blue. Those are willful violations. Willful violations. The difference in the purple, which are repeat violations. Right? Willful violations, repeat violations generally result during follow-up inspections because what the employer said they would do, they didn't do, right? Or they didn't take it across the board and ensure that all pieces of equipment were guarded, appropriately guarded. Right? Willful violations generally result as a result of a fatality, right? Not always, but generally. All right. This slide is, if you can see this up here, RRIs. Remember I talked about investigations? Employers are required to report hospitalizations and amputations. We have two ways of handling those. We can either do an inspection or we can do an investigation, or we pick up the phone and call you, right? Or you call us and then we talk to you about what did you do? What are your plans on doing? Did you identify what the root cause was? What are you going to do to mitigate risk to the employees? This is a slide of the number of RRIs, rapid response investigations that we conducted between the 2 years, right, FY17 and 18. What's important about that? I want you all to know that we don't always go out and do an on-site inspection, right? But what's even more important in that is the rise in RRIs that we received in certain of those NAICS codes. That's what I would take away. You see the rise in 49, 31, 30, which is, oh, now I gotta refer back to it, is no, it's not animal food processing, but it's the, farm product warehousing. And you see the rise in 3191, the first category, which is the animal food processing, right? So you see an increase, and it's up to you to determine if you fall within that industry, what's going on. Obviously, more amputations, more hospitalizations, that's what causes the RRIs. So what are you going to do about it, right? Is there an issue in your facility? What's causing that? And then what are we going to do about it? All right. So how do we balance? Remember, it's a balancing act. How do we balance that? I want to talk a little bit about the special emphasis programs because that is a huge issue for your industry. We have several special emphasis programs that come into play. The first one I want to talk about is powered industrial vehicles, which happens to be number 11 out of the top 20 cited standards in total in Region 7. It is a regional emphasis program. That means every area office in Region 7 exercises this emphasis program, and it applies to material and personal handling motorized equipment. But what the beauty of our emphasis programs right now is there's a tremendous amount of outreach that is done to educate employers, employees, unions about the hazard and how to abate the hazard, how to mitigate the hazard. You also have available to you the OSHA website. On the OSHA website, there's an e-tool which will help you identify, it's an interactive tool, which will help you identify where do I go? If I have a forklift, a skid steer, a crane, a man lift, a hoist, what do I do to abate the hazard? Do I have a hazard? Do I have a problem? What do I do? So it's a valuable, valuable tool that I highly recommend if you haven't been to the OSHA website or accessed any of the e-tools or compliance assistance tools, I highly recommend it. Amputations, a number one reason for a number of the inspections across the board in the grain industry as well as in other industries. It is a national emphasis program, right? And it applies to any and all workplaces that have any piece of equipment or machinery that could cause an amputation, right? The beauty for your industry is that work sites that have 10 or fewer employees do not receive enforcement inspections, but they are included in the outreach that we conduct to educate employers and employees alike. Now this is one, remember I talked about those reporting requirements? You are required to report all amputations, right? To the closest area office, OSHA office, to give us the opportunity. Why do we want them reported? I mean, I ask a lot of rhetorical questions, but we want amputations, fatalities reported so it gives us the opportunity to decide, do we need to do an inspection? Is the employer taking it seriously? Is it a serious hazard? Or do we want to give them the opportunity to investigate it? That responsibility lies with the agency on how we're going to handle it. The whole purpose of an inspection or investigation is not to penalize you. The whole purpose of an inspection or investigation is to prevent what happened from happening again, to take a preventative stance. Right? Combustible dust is a national emphasis program. It covers all types of dust from metal and wood to other organic dust, which grain is included in. So you are part of the grain handling. I believe you already know that. There's a multitude of resources that are available for employers on the OSHA website, including the Safety and Health Topics page, as well as a fact sheet, as you can see on the PowerPoint slide. Many other publications of educational materials that are available to you. Grain handling, that's the one that's applicable to all of you. It applies to workplaces that are covered under 1910-272. This is considered a local emphasis program. It's applicable only in the states of Nebraska and Kansas right now. Right? However, what did you see earlier? It ends September 30th, 2018. What did you see earlier on the slides about the increase in fatalities across the board? Right? And a number of those fatalities have taken place within the grain handling industry, right? So as a regional administrator in Region 7, I do not foresee the grain handling LEP going away next fiscal year, right? So again, it's a prime opportunity for you and I, as employers, as employees, as the association, to work together to really educate employers, employees, and unions, and have a positive impact on fatalities in this industry. How many inspections have we done? Out of the 136 inspections we have done in the grain handling industry, we have done amputations, we've done 9, if you can see that. Combustible dust, 26. Grain handling, we've done 40. And PIV, we've done 18. So about 50% of the inspections we've done in your industry have been planned inspections. All right? All right. Enough about what we're doing right now. Right? Some of the new rules that will have an impact on you, right? Some of the new regulations. OSHA finally published our new walking, working surfaces and fall protection rule. We worked on it for a long time, and it was long overdue, right? The new rule incorporates advances in technology, which we know is light speed, and the government moves very slow, which is why it seems even faster. Industry practices and, of course, national consensus standards have been adopted or incorporated into the new rule. It uses the old subpart D, which is slips, trips, and falls, but it also incorporates subpart I, personal protective equipment, which is the fall arrest system, fall protection systems. The benefit of it for employers is that it affords greater flexibility for employers to decide what fall protection system works best for you. It eliminates that mandate that guardrail systems will be the primary choice of fall protection for employers, right? There's several other things that it changes. It allows employers to select the fall protection system that works best for them. It allows the use of a rope descent system. If it is 300 feet or less, you can't go beyond 300 feet to a lower level. But one of the most important aspects is it prohibits the use of body belts as part of a fall protection system. You're required to use harnesses so that the weight, the forces, are distributed more evenly across the body. This is, and I know this is hard to read, and I so apologize, but this is the new subpart D, and this is the old subpart D. So there are some significant changes in the rule itself. Two of the more important ones are that it incorporates training requirements. Employers are now required to train employees on fall hazards and the equipment critical for fall protection, the equipment that they will use for fall protection that they have selected, and on their policies and procedures that they hope to incorporate. But it also has a discussion of fall protection systems. So it talks about the maintenance and inspection of fall protection systems. The new rule applies to all general industry workplaces. It covers or discusses floors, stairs, ladders, roofs, elevated walkways, scaffolds, and ramps. So it's a pretty pervasive standard. When do you have to comply? As of May 17th, employers were required to train all of their, May 2017, employers were required to train their employees on fall hazards and the equipment that they would be using, right? November of 2017, so that should have already happened. November 2017, employers were required to inspect and certify permanent anchorages for any rope descent systems that might be in play, right? That should already have taken place, right? This November, just a few short months away, right, employers are required to install personal fall arrest or ladder safety systems on any new ladder that's greater than 24 feet and on any replacement ladder or ladder system. So the old existing ladders have been grandfathered in. Existing ladders of 24 feet, greater than 24 feet, must be equipped with a cage, a well, a personal fall arrest system, or a ladder safety system. The critical aspect, we are trying to eliminate the cages and wells, right? So by November of 2036, all cages and wells have to be replaced, right, with a ladder safety system or a personal fall arrest system. Research has shown, comments have shown that cages and or wells are not an effective means of preventing falls, right, or the injuries associated with falls to lower levels. Right? All right. And I'm sure we'll hold questions till the end because I see the wheels turning already. Record-keeping modernization. That's what the common term for the new improved tracking of workplace injuries and illnesses is discussed as, the record modernization rule. Right? It was published in May of 2016, It became effective in January 2017. But there's really two components to the record-keeping modernization rule. The first is the electronic submission of injury illness data, right, which has the hackles of some people raised, as well as the anti-retaliation procedures. Right? Those are the two components. Let me break it down. The electronic submission of records, who has to submit records, is based on establishment size. Not company size, but establishment size. If the establishment has 250 employees or more at any point in time during the previous year, they must submit their injury illness data, right, electronically. If the employer has 20 or more, but less than 250 employees, and they fall within a high-hazard industry listed in the appendix, which all of you do, right, you are required to submit your data on an annual basis, only the 300A. I make a point of saying that this is the way the rule was written initially. Right? Then if you're requested, if you have less than 20 employees, you're not required to submit, right? Unless, of course, you receive a request from the agency asking you to submit your data, right? Which could happen, right? That's the upon notification. Right? The grain handling NAICS codes that are incorporated, that are listed in Appendix A, are all of you. 31 through 33, 42, and 49, the NAICS codes. Right? There's 3 options for submission. Don't mail it to me. You can manually enter it onto a web form on the web page. Right? You can upload a file onto the web page. Right? Or the injury tracking application, which we had a few bumps with initially, is now up and running. You can enter it into the injury tracking application, right? So there's 3 forms in how to get your data in. The deadline, early on the deadline, because remember I said it was effective in 2017, the deadline to submit your 2016 data, which everybody was required to submit their 300A data, was December 2017, I'm sorry. The deadline to submit your 2017 300A data was July 1st of 2018. We received a tremendous amount of data, but I will tell you the agency expected more, and we believe that there are over 100,000 employers who failed to submit their data by the specific deadline. Right? Now the question arises, what are we going to do about those non-responders? I don't have an answer for you. We're still talking about it. We're still trying to decide what are we going to do to collect the data. Right? There's a multiple means or multiple ways we can try and collect that data. So stay tuned for what we're going to do to try and collect that data. After this year, 2018, the 2018 data and thereafter every year will be required to be submitted by March 2nd of the following year. So 2018 data would have to be submitted by March 2nd, 2019. All right? Does that make sense? All right. If you have any questions about the record-keeping modernization rule, on the website, the OSHA.gov website, there is, just Google injury reporting. There is a tremendous amount of information on that website. I will tell you, and this is always sad to me, that once we issue a final rule, there always seems to be a number of interpretations, a number of revisions, a number of steps that are taken to correct things that we failed to consider. Right? We have already announced that we would be opening up or issuing a notice of proposed rulemaking. Came out last year, the announcement that we would be doing, though we haven't done it yet, to reconsider, revise, or remove certain provisions of the rule, right, including the collection of the 300 and 301 data for employers that have 250 employees or more. All right? So at this point in time, you're required to submit, or we're required to submit the 300A, but the 300 and 301 data is not due until next year, and theoretically, that notice of proposed rulemaking where we're seeking comments about the value and whether or not it's worth the agencies, your time and our time, to really submit the 300 and 301 data. So right now, you're only required to submit the 300A data. All right. All right. The second portion of that rule deals with discrimination or anti-retaliation. It became effective August 2016, right? We had a delayed enforcement until December of 2016. Right? There are many paragraphs. Unfortunately, with any rule, there's many paragraphs and then sub-paragraphs, right? Under the rule, the first paragraph, employers are required to inform employees they have the right to report work-related injuries and illnesses. We all want them to report it, correct? We can't do anything about it if we don't know it exists, right? You can't take a preliminary step to correct a near miss, which could result in a fatality if you don't know the hazard exists or someone might have been injured, right? So you have to inform your employees that they have a right to report injuries and illnesses. The second paragraph deals with the employer is required to inform employees, must inform employees that they have the right. Oh, how to report was the first one. How to report, the second one is they have the right to report, but you cannot discriminate against employees for reporting an injury or illness to you. Right? The third paragraph reinforces the fact that employees have a right, employee representatives, employees have a right to access those injury illness records. Right? Paragraph B discusses you have to have a procedure in place, right, for employees to report injuries and illnesses. Then you have to inform them or train them as to what that procedure is. Right? Now, this went into effect in 2017, remember? Right. Have we done anything with it? Right. Let me jump to the next one, I'll come back. Yes, we have. All right. Citations as of January 1st, 2017, let me see, I had a total figure. Citations have been issued under the modernization rule for various components of that rule. The first one, the 35B1, deals with employers not having a procedure for employees to report injuries and illnesses. And there were 9 citations issued. This is nationwide, not Region 7. For 35B2 is employees were not trained on what those procedures were. Unfortunately, we have a propensity, and it's based on past practice, to post the OSHA poster that says they have a right. They have certain rights. That's not enough under the new record-keeping modernization rule, just to post the poster. Right? You have to actually talk to them, train them, inform them of what the procedure is. There have been 11 citations issued under failure to inform employees of how to report injuries and illnesses. The big issues are 41, which is the anti-retaliation, the electronic submission. The first one is employers of 250 employees or greater failed to submit their injury illness data, their 300A. Right? The larger one, the larger column, which is 93 citations, have been issued to employers of 20 employees, 20 or more employees, but less than 250, have failed to electronically submit their 300A. So citations are being issued, questions are being asked. Right? Do you have a procedure? Are you informing your employees? Right? Have you submitted your electronic data? There will be more to come on how we're going to get it. These were issued early on. Right? What we're going to do about the 120, I think it's 128,000 employers failed to submit their electronic data this last July. The last portion of the record-keeping modernization rule is exclusively anti-discrimination, right? It incorporates Section 11C of the OSHA Act, and it incorporates the 35. It talks about 1904.35. It reinforces the fact that employers cannot discriminate against their employees for reporting a work-related incident, and it affords them protection, discrimination protection, if they request copy of the injury illness records and any other provision under the OSHA Act. So why do we need that? Why do we need a specific final rule when we have Section 11C of the Act? Because it codifies Section 11C of the Act. Under Section 11C, we cannot take action against employee discrimination unless an employee files a complaint with the agency within 30 days of the retaliation. So it's a very short window, very short window. The code, the law, now gives us the opportunity, theoretically, right, to issue citations without an employee filing a complaint. And as you've just seen, the agency has done that. We've issued citations for the failure to provide a reporting system and then to inform employees what the reporting system is. Right? All right. Okay. All right. When the new administration took place or took over, there were a lot of questions as to what do we expect from OSHA? Are we going to move, the pendulum going to swing as it has on multiple occasions? I've been with the agency 31 years. I've seen a number of times that pendulum swing from enforcement to compliance assistance, back to enforcement, somewhere in between. There was a lot of discussion as to what's going to happen with OSHA. Are we going to move away from the strong enforcement that we saw under the previous administration to more compliance assistance, right? I have to tell you that the agency, Secretary of Labor, Alexandra Acosta, is truly committed to assisting employers, remember that balancing act, of coming into compliance, learning what the rules are, understanding how to come into compliance, but really reiterating to employers that compliance and safety and health, employee safety and health, is a priority, right? He has not backed off the issuance of willful citations, as you saw in the citations. He has not backed off repeat citations. He has not backed off emphasis programs, significant cases. If you know what a significant case is, it's a high penalty case. He has not backed off criminal cases, nor has he backed off what we call egregious cases, citations issued instance by instance, right? Unfortunately, and I talked about a decline in inspections, we've done less inspections this fiscal year than we have in previous fiscal years, right? However, that being said, the agency had a hiring pause, and then we had a hiring freeze, right? So a number of folks retired from the agency or left for whatever reason, went to other government entities. During that time, when we had a hiring freeze, hiring pause, we lost a significant number of our compliance staff, whether it was in compliance assistance or enforcement activity, VPP, whatever it might be, managers, right? We were at last year, earlier this year, the end of last year, we were at the lowest level for compliance staff members that we had been since the 1980s, all right? We had about 960, 980 compliance officers, right? Secretary Acosta, and included in the we've hired additional bodies in the compliance realm, in the enforcement realm, and we had hoped to hire more individuals in the compliance assistance realm. However, budget is what budget is, and we were unable to hire more compliance assistance specialists to go out and really do the education, to really go out and do the outreach, to help employers figure out what the rule is really saying, right? What are the tools that they can use to come into compliance? What's available to them? In the 2019 President's management agenda or budget, there is room in there, at least right now, that we will hire additional compliance officers, enforcement staff. We're slated to hire, right now it says it will hire 42 nationwide, not in any one region, and we'll hire additional compliance assistance specialists, I believe it's 26 nationwide, and additional VPP people. Voluntary Protection Program people, to go out and assist employers who really want to be part of the VPP program models, leverage those resources. That's what the budget is proposed right now. What's the problem with proposals? It may not ever happen, right? We will see, which is why I reinforce again to you the shared responsibility and how important you are. Whether you work through the NGFA Alliance, the OSHA and NGFA Alliance, or you work independently with your peers, your coworkers, competitors, to really get a handle, identify what those injuries, illnesses are, what the hazards are, and then to fix them. Work with one another. If you have an issue, I am sure someone else has had that issue. Right? All right, compliance assistance. We do a tremendous amount of outreach. I know we're not known for our outreach, but we actually do a tremendous amount of outreach. One of our biggest hitters for outreach is our campaigns, right? We did a fall prevention campaign back in May, the fall stand down, where the whole purpose of the campaign is to raise the awareness to the hazard, whether it's falls or heat or trenching, grain engulfment is to raise the awareness and then to open communications between the employers and the employees as to what their expectations are, what their policies are, what the hazards are, how to mitigate those hazards, right? It's a fabulous opportunity for those conversations to take place between employers and employees, and I will even say members of the public, right, can participate, and are often critical. We also have, in addition to the fall prevention, which kicked off in May, the heat illness campaign, which was also in May, and it's sad for me. Let me go through each one a minute. Sad to say, for the heat illness, we have already had a fatality in Region 7 that we believe is attributed to heat. Right? We're waiting on the coroner's report, but we believe it's attributed to heat. I know people are chuckling. We've had inordinate heat wave in Region 7 this last year, but we've already had a fatality associated with heat. Not in the grain industry, I will tell you. I'm sorry. Okay. All right. Just to set that clear. Our big campaign that we're gearing up for, and we're hoping all of you can jump on board and sponsor it and participate, is the Safe and Sound Week. Right? That is due to be kicked off real soon, August 13th through the 19th. Right? The whole premise, it's a nationwide event. If you you subscribe to Quick Takes, you're probably getting routine blurbs about safe and sound and steps that you can take, how to sponsor it, go to the OSHA website, training tools. But the whole premise behind Safe and Sound is based on your input, employer input, as well as industry input, as well as input from associations, worker comp insurance agencies that have shown a significant impact when employers have implemented safety and health programs. Right? A reduction in injuries and illnesses, a reduction in worker compensation costs, a reduction in the severity of injuries and illnesses, right? The whole premise, the effectiveness of a safety and health program is based on 3 components. Management commitment or leadership. Management has to be involved. It has to come from the top. They model, those practices. Worker participation or involvement. But most importantly, a systematic approach to identify safety and health hazards and then to fix them. Remember I talked about follow-up inspections, repeat violations, willful violations when the employer knew there was a hazard and didn't take steps to fix it. You have to take the proactive steps to fix the hazard. Identify them before someone gets injured, but then fix them, right? If you want more information on the Safe and Sound Week, if you're not already receiving it or feel that you're inundated, please visit the OSHA website, www.osha.gov, Safe and Sound Week, or just Google Safe and Sound Week. Right? We have high hopes for the campaign and the actual event. In addition to all of that other compliance assistance, the presentations, the webinars, the campaigns, OSHA has a number of other what we call compliance assistance tools available to us. You're already part of some of those, right? The alliances. We have a national alliance with NGFA, right? We have multiple regional alliances. The whole premise for an alliance is to work collaboratively to identify or put together training programs. What are the hazards? What are the needs of the individuals in that industry or in that work group? And then what can we as alliance partners do to get the information in the hands of the employers and the employees who really need it to have a positive impact on safety and health in their work environment, right? We also have partnerships, national and regional partnerships. Now, partnerships are more than just educational, they're also enforcement-based, right? So as part of a partnership, OSHA will come out to the job site, work collaboratively with employers, typically they're construction partnerships, but not always, to ensure that all safety and health hazards are identified and fixed, right? We would talk to them and work with them with respect to what are the hazards, what are you seeing, what can we do collaboratively? And let's not forget VPP, the Voluntary Protection Program, is a federal program for employers who want to sail above and beyond the OSHA rules and requirements, which we all know are a bare minimum and woefully outdated in many instances, hence the walking working surfaces, the update of the rule, and the SHARP program, which is designed for small employers, less than 250 employees on a site, or 500 corporate-wide. Excellent programs, all right? Again, it's working collaboratively with safety and health professionals to help you identify safety and health hazards, develop programs, put together training programs. The beauty of the SHARP program, it's designed for small employers, is that they work with you hand in hand to identify and then correct the issues. VPP, we work with you to help you identify, and then we tell you what the issues are and theoretically hope how to fix them, and then you are on your own with respect to fixing them. All right, let's not forget a tool that's available to every employer across the nation, depending on size, 250 site-wise or 500 corporate-wise. Every state in the nation, I don't care whether it's federal jurisdiction or state jurisdiction, has an on-site consultation program. Right? It's aimed at assisting small employers. Again, 250 site-wise, in my mind, is not a small employer, but they're available to those employers if they have less than 250 employees. The employer must request the assistance of the consultation service to come in and assist them. Can be general, or you can be as specific as you want to. I need help fixing this fall protection issue. I would like a safety and health audit to try and determine what are my safety and health risks out there and then how to fix them. But it's an invaluable tool for employers to identify what those issues are, to kickstart their safety and health program. They can even help you develop a safety and health program. It is a confidential program, free of charge. You already pay for it as taxpayers, right? So you're already paying for the service. Why not take advantage of it? The only requirement is that you have to fix the problem. There is no, if they identify a hazard, you have to fix the problem. There is no communication between on-site consultation and federal OSHA unless you as the employer have a serious safety and health hazard and you refuse to fix it. I'm not going to do anything. In my 31 years with the agency, I've only had one employer refuse to fix a hazard, in which case consultation will contact federal OSHA after giving the employer multiple opportunities to address the hazard in a significant amount of time, all right? Like I mentioned, there are on-site consultation services in every state. I'm leaving the PowerPoint presentation with Jess. If you don't know what your contact is, the state of Missouri, the state of Nebraska, all the contact information is here, email, mailing, phone number, or you can access it off the OSHA website. Again, the OSHA website is just filled with all kinds of information. Right? Nebraska, Missouri, Kansas, and Iowa. Right? I highly recommend that you avail yourself, if you fall within that category, avail yourself of that opportunity. Okay? Questions? I don't know how much time we have left. We do? Okay. All right. Well, let me make.
Can you hear me now? Okay, great.
Okay.
No.
Before you get started, I'm remiss. I would like to introduce my people that are here. All right. So you can put a face to a name. And if you'll stand up when I mention your names. Jeff Funk is the area director in the Omaha, Nebraska office. Right. Matt Thurlby is an assistant area director in the Omaha, Nebraska office. And Dave McDonald is one of the 3 compliance assistant specialists we have in Region 7. Great resources, great information they're willing to impart on you anytime. Right. Okay.
All right. So
Now
we have about 10 minutes for questions. I
Okay.
have a few questions, if you don't mind.
Okay.
And I must say, it's great working with you through the alliance, through the national alliance that NGFA and OSHA have. I think it's been very productive that we've had the last year, and I know Kim and David and Jeff, I know you've been very involved with it, and really appreciate your help being part of the team and the stand-up campaign that we had today. And I know you all will be at our Safety, Health, Environmental Quality Committee meeting this afternoon. So a couple of questions, and I just want to clarify. The data that you showed up there was specifically for Region 7. Is that correct, or was that national?
Yes,
So
Region
all
7.
the specific data for the grain industry, for all the citations related to record keeping and so forth, those were all Region 7?
Record keeping was nationwide.
Record keeping
Right.
was nationwide, and the other industry-specific data?
It was region-wide. It's just region.
Region-wide,
The
okay.
the record keeping is nationwide. However, I will say we have issued, Region 7 has issued 1 citation. under the record-keeping modernization rule.
So-
We just issued it.
So what kind of citation? Is that a serious
They're
citation?
all other than serious. The citations are all
serious.
other than serious.
Okay. That's very.
That's good to know.
Yeah, that's interesting. What about the walking working surfaces standard? Have there been any citations issued for that particular standard?
Now, I did not pull that data, and I apologize for that. We may be able to address that. I'm not sure if Dave did. We may be able to address that in the committee meeting. That's a very good question. I will
Okay.
get you that information.
Just-
I apologize.
Just kind of curious. Okay. There have been? Okay.
I can speak for Nebraska, but that's it.
Okay. Well, if you want to speak for, we have a few members from Nebraska in here.
All right, the only information I have is Nebraska, okay? I can tell you that we issued around 12 to 15 1904-41 violations this last year. And that's for employers' failure to submit their 300A. That occurred. We had a cutoff of June 15th is when that happened. So those were other than serious, no penalty, if the employer immediately gave us their logs. And most did. Actually, all did. As far as walking working surface, we have issued a handful. They're mainly guardrail violations, some fall protection maintenance issues. If you have a retractable lifeline for like a rail car and you leave that fully extended all the time, that's a violation under the walking working surface. You're not keeping your fall protection maintained the way it should. In one instance, we had an employer that experienced a fall with their retractable lifeline and didn't replace it per the manufacturer's recommendation. So that's one in your industry that I can recall. But, it's the citations we're issuing are very similar to what they were under the old standard, at least in Nebraska.
And I will tell you, you all know that fall hazards are the #1 reason for fatalities across the nation, not just in Region 7, but falls in general, the #1 reason for fatalities.
Another question that I always get often, and I'm sure you have the answer to it, is why hasn't the Senate confirmed the nominee for the assistant secretary position?
Oh, you have great faith in my insight. I just had that discussion with our deputy, Lauren Sweat, who is filling in those shoes. She's doing double duty. I don't know how the woman is a Wonder Woman. I don't know how she does it. The only response I can get you is that there's a lot of things going on in Washington right now. There's a lot of moving pieces. There's a lot going on right now, and OSHA seems to be pretty self-regulated, self-controlled, and Lauren's doing a great job. I'd like to think the regional administrators, the regions, the area officers are doing a great job. So it has not risen to the top as a high priority. That I know that doesn't help you much. But there are a number of things, I'm sure that was your next question, there are a number of things that are looming out there that we are truly waiting to issue until the assistant secretary is selected or is confirmed and can put their personal mark on those.
Exactly, and a good example would be for if there was, say, a letter of interpretation. So
Right.
if there was a letter of interpretation on an issue such as the walking working surfaces standard, that could be sitting there in the queue waiting for the
Yes.
new assistant secretary to have a chance to review and provide their stamp on it. Correct?
Absolutely.
And until then, a lot of those types of issues, or items, I should say, are just kind of just waiting.
Absolutely.
And I think it's, and just to follow up on that, the assistant secretary position for OSHA, assistant secretary the formal title is the assistant secretary of occupational safety and health within the Department of Labor. That position is confirmed by the U.S. Senate.
Right.
So the nominee they've had their hearing, they've passed out of the committee, and now their formal vote is awaiting on the floor of the U.S. Senate. So basically, not until the Republicans and the Democrats agree on a date to schedule a vote on that candidate, they're essentially just sitting there. So that's kind of how it works. Until then, as you said, Lauren Sweat, the Deputy Assistant Secretary, is the one that's pretty much going to be making sure the trains run on time, so to speak.
Absolutely. And God forbid any horrific mass casualty situation where it would really elevate that confirmation hearing to the top We don't want that to happen. So this is a critical time for all of us to work together collaboratively to ensure that that doesn't happen.
And I know we just have a few minutes,
Yeah.
but I think if there's any,
Specifically for the electronic logging or reporting of injuries or incidents for employers that are 20 to 249.
Right.
The standard is really, really clear when it comes to if you have an establishment. It's great at defining what establishment is,
Right.
and if you have an establishment that has multiple locations on site. I think plenty of people in the room might have questions, as I did, on how do you determine if you have to electronically submit your records if you have facilities that are located 2 hours away from each other that might have less than 20 employers. You know, they're all agricultural, so they're all going to be the high hazard. But I had a few people ask me questions. We're a consulting firm. Had me a question on how do we have to electronically submit if we have 12 different facilities that are maybe 2 hours away from each other. Each of those facilities only have maybe 8 or 9 people or fewer, but they all report to a particular location. You know, that, how do they determine whether or not they electronically submit in those situations?
There is an FAQ, a frequently asked question, on the record-keeping page that addresses that very question, and it's based on, record-keeping has always been and will continue to be establishment-based. It's work-site specific, right? So if the employees report to one work site, and that's a location as well as a physical address as well as worksite locate, I guess it's a worksite location, that's one establishment, right? If it is, even if it's different NAICS codes or same NAICS codes at 9 different work sites, it's based on that location or that establishment. Now, do they all report to one location? Or the physical address to where they do their work is 9 different sites, 12 different sites, whatever it might be. It's based on that establishment and their location, because record keeping has been and will continue to be, under record keeping modernization, site specific. No, no.
I think we have,
Yeah, I've got-
is this a transition into your presentation?
no,
or-
just a question. Kim, I wanted to ask clarification about something I thought I heard you say about the electronic record-keeping rule, about the anti-retaliation provisions where there's a duty to inform employees of their right to report free of retaliation.
Right.
I thought I heard you say that posting the OSHA poster was not sufficient. And I have been advising, and if I misheard that, clarify that, there's the 2015 version, which is the most current version, has those rights spelled out. And I've understood that just posting that poster does meet the duty to inform. If you have an older version of the poster, which you legally can have, but it doesn't make sense to not just update it, if you have the older poster, then there is a proactive duty. Do I misunderstand?
No, you're
that?
correct, absolutely correct. But the poster in and of itself does not constitute the procedure. You still have to have a procedure,
procedure.
how to report, right.
Gotcha.
No, you are right, the poster is sufficient.
Do we have, I think we have time for maybe one more question?
Sure. Well, ask the next presenter.
I'll stay on that same topic. If I have a well-defined corrective discipline program for safety violations, and I take action under that, and the employee does report, what is the process? If I have a burden of proof there, or what happens?
So you have a defined, tell me again.
So I have a defined corrective action or discipline
You have a
program
discipline program,
for safety violations.
okay?
And so I discipline the employee under that program. Even though they report, do I still fall under the retaliation, or is there a burden of proof? Or
Yes and yes. The employees will always have the right to report or file a discrimination complaint to report. We will never be able to take that away. They always have the report. Unfortunately, employees have a propensity to, when discipline is enacted or rendered, the first thing an employee will oftentimes do is file a discrimination complaint. They discriminate against me. As long as you have a procedure, you have a policy, and you adhere to that policy, there are no disparities, you're not showing preferential treatment, you've not enacted your disciplinary program disparately, you would be fined as long as you can justify why you've done what you've done, right? The agency will never take away your right to discipline employees where they don't adhere to safety and health practices. Your safety and health practices are safety and health practices. In fact, that's one of your primary rights as an employer, right, is to ensure that there is a procedure in place, employees are aware what that procedure is, and you take action. You discipline where there is missteps or where there are acts of noncompliance.
Well, I would ask you about boot pits and confined space, but I don't think we have time for that. Maybe we could talk about it during break. I know we have our next distinguished speakers up here, but Kim and Jeff and Matt and David, they're going to be here for the rest of the conference. They'll be here for the break, so if you want to have a sidebar conversation with them, I'm sure they'd be happy to chat, but we're going to move right on to our next session. So Kim, thank you very much. Thank you.